Salute squad. Salute squad. Welcome back to another episode of Fly High Productions with Mr. Follow. Hey, so check this out. Uh I actually missed court today, right? But I heard it was some exciting things going on. So what we gonna do today, we gonna slide up in this courtroom. Let's slide up in here and see what we missed. For all my live viewers, let me know what city you feeling it from. For all my replay people, drop your state in the chat.
I trust you had a productive evening last night and understand that parties have a proposal with regard to the portion of Mr. Copeland's testimony.
Sorry, I didn't have this turned on. So what I said was I trust everybody had a productive evening and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe that the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once the defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there.
All right. So I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. That seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you've gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Don't think? Otherwise, give me something else we can do this morning.
Yes, we can do that. You can, we just need that. We just need to get that material very quickly to the office, to the courtroom.
All right. Send somebody to go do that, please. And has anybody thought through yet, and maybe we'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Yeah, given the conversation Ms. Hilton had with the defense last night, in that some of them maybe seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions. I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams cannot opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
Well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief of the main case. I'll get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that. Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list. Talking about how we can resolve working through the exhibit list. And my understanding from Mr. Sharp, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant were actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
the giant list of
list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your Honor.
I thought you meant Mr. Copeland's testimony.
No,
okay,
Your Honor.
All right, my misunderstanding then. Okay. All right. So, with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, the law, regardless of us arguing our various sides, the law probably is this and we're okay with that ruling?
We believe
That's,
out of them, we believe, and I'm sorry, Your Honor.
go ahead.
Out of them, we believe that there might only be 2 that we think may need to be re-argued.
Okay.
We don't think there's many, at least from
Okay.
the state's
All
perspective.
right, that's good. This is the bias.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on at trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say today. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, That last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well,
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get.
Hey, you! Stop what you're watching right now. If you drive your car less than 100 miles a day, then I'm about to show you a simple trick that can put hundreds to possibly thousands of dollars.
So enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing.
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that To the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but...
I add one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on actually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and the 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Thank you.
Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else do we do that's productive?
Your Honor,
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. He will then, I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight because.
All right, we pulled up to the winner's house. There are cars in their driveway. That's a good sign. Doesn't mean they're home, but let's find out. Oh, someone's already here. Yeah. Hi. That's good. Are you Melinda?
I am.
Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this honorable court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding. It's over. The case, no one looks at prejudice. But the two cases that came out in April One of them may have been in January, but I cited them in a footnote of my motion to just educate
Okay,
the
well,
court.
if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases and what,
Step back.
okay,
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there is not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both of them. Judge Glanville,
You can proffer what he would testify to.
then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that that did not happen or this. I want to get it right.
all right, so you haven't talked to him yet about what? All right, well, obviously, I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half?
Yes,
Okay.
thank you.
All right, let's come back at 11.
Does the court mind that we stay in here?
Doesn't matter to me. If that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
Have a case law about your direct question regarding the prior inconsistent statement and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? Your Honor, I have three cases for the court.
Okay.
I have Green v. State. I have a copy for the court as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconnors v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for Sixth Circuit. It's an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes, thank you.
Oh, sorry, I'll give it to you. I gave you green already, Mr. Washington. I gave you green already. Which one did I give you? Okay, you're welcome. You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the one I've looked at so far, is there one that says, if you say, yeah, that was a total loss?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble. and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making
All
a
right, so hang on. You're talking too fast for the court reporter to take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency.
Okay.
But that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your
All
Honor.
right. Thank you. Appreciate it. Counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Matt Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't, because we...
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what the...
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I lied started early in his testimony. So, but we can.
Thank you. And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said that either late today or tomorrow morning she should have, I believe it's June 10th. June 11th, and then we'll be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions in that.
All right. So do we already have the 10th? somewhere. We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, that y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-983. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to argue with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes. Thank you.
All right. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the state as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
Or it was what was hashed out during
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done. 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the others, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make come to agreement on.
And we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So.
All right, I'm not sure I follow you.
Okay.
So. What you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion, and then we can just say that's what we're going with because that was prior to any issue, and therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, I thought y'all wanted to figure out what was actually done and what wasn't.
And I guess maybe I misinterpreted what the court, I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you want to revisit that one?
Yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
And respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yeah.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Short is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So.
Seems like it was.
Okay. All right. So how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary, sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
The belief that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's gonna.
Okay. So for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7, lines whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then, of course, if in court I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. All right, I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy.
Y'all are all old like me, and you like paper.
And because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today, so
Yeah.
I didn't bring the transcripts with all my notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understand.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said you were only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and other witnesses that you're going to be getting to soon?
Can we stop talking about little wood?
We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team over the next, however amount of time the court wishes to allow us is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several we can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that. Yes.
I said it, so
You did say it.
You know, there we go. But I overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
It's not anything. It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd of last year, obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same, they only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out, a year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay, understood.
So I want to get that on the record. And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count 1, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you with that, whether you ultimately do that or not.
I don't know. I'll hear from both sides. But
yeah. It's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right. So we'll get you that
as
soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang at trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial or in the presence of a defendant currently on trial that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Okay.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6, 2023 notice.
Okay. November 6th. November 3rd?
It's just, he said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right, 3
Right?
specific ones.
Okay.
Yes.
Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the court.
case. But Ms. Persifield has saved it for me somewhere, but there are already a lot of things in our file also.
We'll
So,
send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Is emailing it to me because I need lots of assistance. Thank you, Laura.
I don't think Love was understanding what she was
And so
saying.
was there an order at some point or a
I'm saying,
direction
stop putting all
from
that
the
stuff in my
judge to
inbox.
tell the defense
All these motions that I
which
spoke on earlier.
statements you believed to be co-conspirator statements that led to this supplement? Statements you believed to be Yes, okay. I mean, if there was, that's all I need to know. So yes, so, okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included when you were as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it.
Yes.
Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Yeah, cool. 1 second, I'm reviewing.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to.
By which you mean your laptop overheated?
I do mean my laptop. Okay. And I was
because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
Yes, sir.
While she's waiting for that to
sure.
come up, could I just briefly address a side issue?
Sure.
When we met for the status conference,
yes.
I believe Mr. Harvey asked you if you would support us when other judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
thank you so much.
Yeah. Mm-hmm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. Mm-hmm. So you were referencing that week last week where we were out and why we weren't working to prepare for this.
Right.
I was being called into court all over the state of Georgia, just because, and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation to do for this week, but unfortunately, I was hauled over all over the state.
Right, and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, we may just have to decide that on a break by break kind of thing, because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say
What are
go
we talking
Monday
about
through
her?
Thursday hard
This
and
is
take
dude
Fridays off,
about his
or take
third time
Friday mornings
mentioning
for
it.
motions and
Man,
Friday
sit down.
afternoons
Let's
off
get
or
on with
something, but
court.
like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That
But-
would be wonderful, Your Honor.
Yeah.
At least speaking for
Yeah, but
just for
yeah,
myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer right
Okay,
now.
thank you.
Okay. All right. How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
What y'all think, Squad? I don't think it's going too good for the state right now. I think the state, I actually think Adrian Love and the judge gonna clash in a minute here. It ain't taking too long.
Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this
Yes.
specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties.
Okay.
To speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
I'm ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
For this particular portion.
Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator, you, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who
is-
is also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your
All
Honor.
right, Sumlin. And you can do the same for him?
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the number.
That's fine. I just was like, if it's two, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5,
Jail calls?
about a portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it was a part of the notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, well, y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else? All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know?
Yes.
Thank you. Do y'all, deputies, you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
That's a quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that,
during lunch.
I referenced where it said that you can't use.
Okay.
Matter of.
That'll be great.
Thank you.
Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
All of them, when the court had asked me earlier, whether in all of the jail calls, all of the wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. Okay. So yes, thank you. All right, in recess.
Yeah, squad, y'all with me? Can y'all hear me good? Check this out, squad. This what we gonna do. If they taking them a lunch break, I'm going to get a little dinner in me, squad. But let me know, like I say, if you're watching it live, throw your city in the chat. If you happen to be watching this replay, let me hear from you. Drop your state trying to see something. Until then, Fly High Productions with Mr. Follow Up. I'm out. Squad up.